The appellate court ruling on the Federal Defense of Marriage Act is like the proverbial tail wagging the dog. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, not long ago, a few days ago, the U.S. Circuit Court of Appeals for the First Circuit up in Boston, Massachusetts, heard the issue of the Federal Defense of Marriage Act and ultimately found that it's unconstitutional. They didn't find the whole act unconstitutional, but they found what's called Section 3 of the Federal Defense of Marriage Act unconstitutional, which is different than the full faith and credit clause one, the one that says that states don't have to recognize out-of-state marriages. That wasn't at issue. What was at issue, however, is the definition of marriage, so that from a federal perspective, federal law and federal benefits only recognizes marriage between spouses, such as between a man and a woman, not between people of the same sex. That's the provision that was under attack in this case before the Court of Appeals.
And we ultimately know that this will go before the United States Supreme Court. They will make the final decision on either this case or the case that is coming out of the Ninth Circuit, the Proposition 8 case in California. And, you know, this is just another example of how the homosexual activist lobby has to circumvent the democratic process, circumvent the legislative process, go through the courts to try to overturn a clearly constitutional law that passed along bipartisan lines overwhelmingly and was signed into law in 1996 by Bill Clinton.
Well, and why we said that it was the tail wagging the dog is this. The argument is that Massachusetts now allows same-sex marriage. Well, that's Massachusetts. So what they're now saying, however, is that since Massachusetts allows it, then the federal government ought to give them federal benefits. Now, Massachusetts is not being prevented from doing what it's doing by the Federal Defense of Marriage Act. It is allowed to do what it's doing now. It's allowed to give whatever benefits it wants to, and that's what they've ultimately done through their court system, through an activist court system. But what this case actually is not that they're being deprived of state benefits or the right to redefine the institution of marriage, but that since Massachusetts has set up a different standard than virtually every other state on marriage, then that standard ought to trump everything else and ought to demand that the federal government give them benefits. So it's essentially saying that the states can define any kind of eligibility they want to for federal benefits and force the federal government, contrary to what it does to the other states, to give that particular state benefits based upon that peculiar new definition of benefits in that particular state.
Sure. The First Circuit here is essentially saying that as inverting the supremacy cause and saying that the state of Massachusetts has supremacy over the federal government, and when the state of Massachusetts decides to redefine marriage, that the federal government has to follow suit and adhere to the dictates of the state of Massachusetts. You know, we often say that DOMA, the Defense of Marriage Act, is the last firewall. It's the barrier, the dam protecting the floodgates from opening for marriage. Now, this case doesn't do that, Matt. Correct? It doesn't necessarily open the gates for Massachusetts to redefine marriage for all the other states.
No.
But what it does do is it opens the floodgates and says that the federal government must obey the dictates of Massachusetts.
It'd be like the federal government having a certain retirement age for Social Security benefits. You know, you reach a certain age and you're eligible for Social Security retirement benefits, and that goes across all 50 states. And one state says, well, in our state, we allow people to retire at the age of 60, not 62 or 65, but at 60. So therefore, they can get state retirement benefits. And they ought to also be able to get federal retirement benefits. Even though no other state can do that, our people ought to get retirement benefits at a different time because that's what our state does. That's essentially what this situation is. Massachusetts has adopted the same-sex marriage, and it's not being interfered with in the state. It's doing whatever it wants to do. But now they're saying we want benefits in the sense of we want to be able to file joint income tax returns. We want Social Security survivor benefits. We want federal employee health insurance benefits and medical benefits, anything else that you would otherwise get as a spouse. And under the federal law, spouse is defined as a union between one man and one woman, not between two people of the same sex. So this particular decision, I think, is a good case to actually take before the United States Supreme Court. I think it's a better case to take before the United States Supreme Court on this issue than the Proposition 8 case out in California.
Well,
and in fact, since this law was struck down, found unconstitutional, at least Section 3, it's a mandatory review by the Supreme Court. So this is not essentially a discretionary situation. This will go to the U.S. Supreme Court.
It's on the fast track. It'll probably get there before the case out of the Ninth Circuit, the Proposition 8 case, correct?
Correct. No,
yeah. And what's good about that, the silver lining in terms of this case, is not at issue in this case are the provisions within DOMA, the Defense of Marriage Act, that say states, based on their own public policy, get to define marriage for each state, and we know, 32 states out of 32 states that have had an opportunity for the voters, for the people to look at it, they have overwhelmingly supported. It hasn't even been close in terms of percentage points. Overwhelmingly supported a natural marriage, real marriage in those states. So that isn't even at issue here. So again, this is less threatening than the case coming out of California.
Yeah, it really is. And in fact, if you look at the case in California versus this case, the case in California ultimately struck down a state proposition, but not a federal statute. And when you strike down a federal statute, that's going to be an automatic review by the U.S. Supreme Court in most cases. The one in California also potentially is limited to the impact only on that particular state and doesn't go outside the rest of the states. But this one, obviously striking down Section 3, the federal definition of marriage for federal purposes, affects everyone. So this one clearly is going to the United States Supreme Court. And the person who is on this case is Paul Clement. Paul Clement has already argued about 64 cases before the United States Supreme Court. He was the acting Solicitor General under the Bush administration and then became the Solicitor General. As Solicitor General, you get a chance to argue whatever cases you want to, cases that aren't even related to cases that you're working on. You can intervene and have 10 minutes, for example, in each case. So he's had a lot of those, but he's also had some major cases. In fact, during this past term, he has argued 7 cases before the United States Supreme Court, including the Obamacare case and the Arizona immigration case, among others.
Which, when he was matched up against the attorneys for the United States government for the Obama administration, it wasn't even close. It was a little embarrassing the way that he clearly outperformed the government's attorneys.
Well, he's one of the best oral advocates at the Supreme Court level that you can have, and so I'm glad that he's on the case, and he'll do a good job when this goes to the United States Supreme Court. He always argues with absolutely no notes. He goes up there with no notes, and he does a dialogue, and he knows his material. So this is a case we'll continue to watch. Liberty Counsel filed an amicus brief in this particular case, and so as this case goes to the United States Supreme Court, we will also file a brief at the High Court as well. This issue, though, the battle over marriage, is a fundamental reshifting and realignment of our culture. And it is not just simply having two people living together who love each other, and therefore you give them some recognition. It is literally a redefinition of our culture, a redefinition of family. And when you essentially say through same-sex marriage that moms are not relevant to children and children can do just as well with or without a dad, that's what same-sex marriage does. And that is a radical new policy shift that will have consequential and, in fact, detrimental damage to children, to our culture, and to America. And when you destabilize the family, Matt, you destabilize everything else.
Well, exactly. And the Obama administration, Matt, as we've pointed out before, has abrogated its duty, has refused to defend DOMA. So it looks like it is going to be the United States Supreme Court that has the final say on this issue. Where does it go from here? What can we expect a timeline for the court to look at this?
Well, they've got 90 days to file their petition, so sometime this case could be argued either in the fall or early spring of next year with a decision by the end of June of 2013. Go to Liberty Counsel's website for more resources on this and other issues, but one of the issues that I think is fundamental and foundational to this issue is a book by Dr. Judith Reisman, Sexual Sabotage. Dr. Reisman is a world-renowned expert on Alfred Kinsey and the effects of Kinsey on human sexuality, which of course includes same-sex marriage. Alfred Kinsey is the one who ultimately radically reshaped our culture. Learn about it. Learn what you can do about this issue. Ask for Sexual Sabotage by Judith Reisman. You can go to Liberty Counsel's website at lc.org or call us 800-671-1776.